Good morning. I'm Ahmed Elnaggar and this is Monday Legal. My guest for today is my colleague. His name is Ahmed Gabr. He's a senior associate at Elnaggar Partners. Good morning, Ahmed.
Good morning, Ahmed.
Thank you very much for finding a place in your very busy schedule that I'm aware of to come here and to talk to us about legal topics.
Sure.
I would like to start by giving you a chance to introduce yourself. But first, can you tell us what's your coffee?
My coffee, the preferred one is the espresso. The more it is strong, the more I fall in love with it.
How many espressos you have per day?
Per day, from 2 to 4, depends on how busy am I.
That's a lot, man.
Kinda.
Okay, take care of your health.
Yeah.
Can you please tell us a little bit about your legal upbringing? How did you start with the law? Why did you choose law school in the beginning?
Well, in the beginning, I had like a few options to choose between, and I chose the law because my father is a lawyer. So I felt I'm in home after all, and I will have a good mentor to go through the entire process of the education. There will be more information about how things are going in the law. So basically, that was the favorite part of studying law. During the education, it was good amount of knowledge, information, but still, when you graduate and when you face the true life and how things going on the ground, not in the books, is totally different. And from there you gain experience. I started with a governmental entity in Egypt for 3.5 years. Then I decided to work we call it as a freelance lawyer in Egypt.
Well, which government entity you work for?
It was the military. I used to work for the military for 3.5 years as a prosecutor. So I used to work in a very private sector of law, which is the military law. So basically it's very private courts, very private judgments, and very private nature in itself. You can't take it over and measure it to the general law that we're practicing day to day. When I finished my recruitment, I started to pursue as a freelance lawyer. I worked in the criminal sector for almost 1 year. I got the chance to expand my experience and to pursue better career outside. And that's why I flew to the UAE. And the true experience actually started when I landed to the UAE. I was very lucky to work with all of the law firms and the private entities in the past 6 years in the UAE. I've honored to work with very experienced mentors all the way until now. I'm working as I could identify myself as a diversified lawyer. I worked in law firms and I worked in private sectors where I'm acting as an in-house counsel or as a private legal advisor. I had the chance to experience the law from the dispute settlement sector and from the creation sector, where you're creating the dispute during the drafts of the agreements, of the contracts, of the mutual understanding of the parties. And that actually gave me the experience that I have right now. And for sure, Elnaggar Partners, the past 4 years, I'm so honored.
Do you mind if you're telling us which university did you study and past law firms and positions that you work for?
Sure. In my education, I was honored to study in University of Alexandria, College of Law for 4 years. Then I graduated and I graduated in 2014 and I decided again to pursue studying in 2021. And I joined the University of Salford, Manchester, UK, and I got my master's degree in 2023 in December. This is from the educational part. I worked with many law firms in the UAE. I worked with OGH Legal in a trainee position when I landed, and I worked with Emirates Advocates. That was the first unlimited contract I had. I learned a lot over there. I worked in very diversified environment where I had to work on the intellectual properties, in the litigation team, in the corporate. So I made a lot of connections there, and then I shifted to some private sectors during COVID. So things were not the best, but I've been jumping between many law firms that I was very honored to work with. And then I joined Elnaggar Partners in 2021 in May, all the way until now. And I feel myself very lucky to work in Elnaggar Partners.
We're very lucky to have you.
Thank you so much. It's the most diversified environment I ever experienced so far because we are doing a lot of things. That gives me a lot of experience in a very short period where I can feel confident about my approach to cases, to advising clients, to building a legal opinion or a firm legal opinion that can help me and my client later on. So that's it.
What's your focus right now? What is the most area where you practice?
The most area I'm practicing at the moment is the tenancy disputes. We can say between agreements and between disputes. This is the most common area for my client, whether they are individuals or companies, they're still facing the same issue in tenancy. Whether they are taking a tenancy contract as a residential or as a commercial, there is a problem. There is a problem during the draft of the addendum, which considered as an integral part of the contract, and most of the investors or most of the individuals counting very, very much on this addendum, while this addendum have a lot of secrets. At the same time, the issues that appears later on after incorporating contract, a tenancy contract, whatever the nature is. But I feel that this area have a lot of issues and have a lot of problems at the moment. And this is where I'm trying to focus. I can really assess the needs of my clients in this area.
Yeah, one of the very common problems that we face or we see that our clients are facing is that they come to us after signing the contract, and they come maybe after 7 or 8 months within the contract and say, we signed a standard agreement that was provided to us by the real estate broker company who introduced us to the unit, whether residential or commercial, or even a warehouse that is given to us by the free zone authority or so. They didn't read it. They don't actually spend enough time, and they feel like that's a standard contract. The landlord is not going to change anything in it, or is not going to negotiate any part of this agreement. Is there something like this in the law? I haven't read it. I know very well the law, and every time I get so shocked, like, why do you believe these things? Why do you think that there is a contract that is unnegotiable? It's very strange.
Of course, I agree with you. And unfortunately, the client comes to you in a very, very, very critical stage, in a very critical point where the contract is already registered, it's valid, and both of the parties are actually have the obligation to respect the contract terms, whether it serves your interest or against. So actually you are in the end of the tunnel, and then you are trying to find a way back. Unfortunately, at this point, the individual or the company who decided to get into this contract 7-8 months ago, they didn't know that this contract is negotiable. Nothing in the world is not negotiable unless you are dealing with a governmental authority, or unless you are dealing with a bank in a credit card or in a loan. You the one who needs, but in the tenancy contract, you need as much as the landlord needs as well. He wants money and he wants a space. Simple. So all terms can be negotiated, whatever the term is, as long as the negotiations falls within a proper and reasonable measurements. And all of this falls under the laws and regulations in place. Because at the end of the day, the last line of protection you have is what the law states, not what you have agreed upon with the landlord. So that's why before getting into a contract, it's very advisable that you seek advice on stuff that you don't know about. If you reach this stage and you deny the advice, then I don't think thinking otherwise later could be beneficial.
Yeah, in many occasions as well that we face that let's say the promises that were given to the tenant or even to the landlord in some occasions, that I'm going to do this, don't worry, I'm going to do this. It doesn't really have to be put in writing. We're going to do it. And some verbal agreements that happen, and even sometimes it happened through social media, like, I don't know, WhatsApp group or a WhatsApp communication between the landlord and the tenant. Things were promised but are not mentioned in the contract.
Yeah.
And have you seen any case where we could build an evidence based on verbal communication or even written communication in other mediums like social media or WhatsApp communication that is contradicting with the contract?
Well, actually, yes, a lot of times I've seen this, and the issue is that the tenant doesn't actually distinguish between the agent and the landlord. there is a huge difference between both of them. The agent is just a third party who puts the two main parties together. He will take his commission and you will never see his face again, unless the next year he will come back to you again, approach you. Hey, did you find the lease, or you want me to assist you? So during the 12 months, whatsoever obligation is, it's only yours. You cannot claim that I was promised by the agent. I was promised by the agency. We have agreed, me and the agency. Actually, the agreement should be done only between you and the landlord. In this part, if you agreed with the landlord on something verbally, is the weakest evidence that we can stick to. Kind of like nonsense, verbally. It's verbally. I promise you that by second month I will do this, and then the second month he will come back to you if he decided to, and he will deny, or he will approve, yes. So it's 50-50%, it's your luck. If the landlord is honest enough to respect his word or to respect his verbal promise, and if he's not that honest, then you will suffer.
There's also a time element, like for example, I promised you something and later on we have agreed on something else that is contradicting to it and that is in writing. So even if I don't deny the promise I gave you, I maybe said, I promised him this, but then later on we have signed with different terms, so I understood that he read the contract and he agreed to it. So I don't think even denying is the element. There is a time difference between this kind of verbal promise and an agreed term that's mentioned in writing. What about the WhatsApp communication? And if there's a message or any other medium, email, for example?
For sure, the WhatsApp communication, emails, and any written formula is taken into consideration. However, again, we should measure what was promised in a written form with what was agreed upon in the contract. Because at the end of the day, the contract shall prevail any other promises and shall prevail any previous agreements. And the contract is basically what all of these agreements, promises, negotiations, and understandings between the parties have ended up to. So basically, the contract is the last exit from these negotiations, and that's why it should be not only well drafted, also well reviewed. In the Emirate of Dubai, the contract is being issued by the authority. So basically the contract doesn't have that much options, and that's why usually the tenant and the landlord goes to the addendum, to the tenancy contract. I can say that in the past 3 years, I've never seen a single lease contract, whether it's commercial or it's a residential, that doesn't have an addendum. The thing is, the addendum itself, in order to be enforceable, it should be taken into consideration from the element of incorporation. Did it incorporated on the same time of the incorporation of the contract? Is it an integral part of the contract? It was decided later after signing the contract. All of these elements can stand out the addendum to be a valid tool or invalid tool. This is a very crucial part, because again, if you're counting on the addendum to make sure that this addendum is in your interest and it was well drafted, but you did not notice the procedural requirements of recognizing an addendum before a court or before an authority, then the addendum will be invalid. And if it's invalid, again, you will go back to the standard terms of the contract, the standard terms of the lease agreement, which is very basic, which doesn't have much more information than the information of the parties, the leased unit, the rental amount, the security deposit, and the period of the tenant.
There is kind of a space that is given as an option, even in the standard contract, for special terms.
Exactly.
And this is somewhere where a lot of points can be mentioned. Exactly. And within this, you can put that there is an addendum that is part of the agreement. Exactly. And then you put the addendum with the full terms 100%. And conditions and so on.
100%. This is the incorporation. This is the proper incorporation, that you need to mention the addendum in the contract. Make sure that the both dates are the same, signatures on both of the contract and the addendum, and to submit both of them as one contract to the authorities, which will be incorporated later. So later on, in case of a dispute or in case of disagreement, the addendum can stand out and protect your rights as a tenant.
And as much as you can put in it, the law allow quite a big room of agreement and special terms between the landlord and the tenant. And if they just regulate the early termination, they agree on penalties if there's any bounce check or delay penalty on the payment of the rent installments. And there is a big room. Just please read the contracts, because it is very important for regulating the relationship between a tenant and the landlord.
100%.
Does the law specify special terms for residential and commercial properties or not? I'm talking about the regulations governing the rentals, the tenancy.
This is a very, very intelligent question because actually it's common between the individuals and the companies. We know that the law issued in 2007 and the addendum in 2008 mostly used for the residential tenancy contract, but very, very few of the people that are not specialized in the law, that are not doing law actually, that who knows also that the same law applies to the commercial. So basically the tenancy law number 26 and the addendum in 2008, both of them are governing the residential and the commercial lease. However, to some extent, we're only that will be only concerning the professionals in the legal field who are actually working on the tenancy dispute. We know that also some of the civil transaction law and the commercial transaction law, some of the articles also involved into the commercial lease due to the commercial lease nature. It's a commercial nature between two entities. Also, the landlord is an entity, the tenant is an entity. So and the usage of the unit itself is
for a commercial purpose.
So basically, the commercial law will jump in, the civil transaction law will jump in, and the main umbrella is the tenancy law, which applies on both residential and commercial.
Tell us about the major differences between a residential tenancy agreement, which is quite simple, straightforward. You find a template and you can work on it. I don't advise to work with templates, but you can, to a certain extent, rely on templates for a tenancy agreement, tweak a little bit in it, and it's easy to formulate. And my advice is not for the end customers or the end client. My advice is for lawyers. But about commercial properties, when it comes to offices or warehouses or retail shops, we've seen a big difference between these two different drafts because there are different regulations, because the landlords are different as well, whether it's a shopping mall or is just a retail unit in a residential building in some areas in the country, or a regulator or a free zone authority that is leasing offices. There's a big difference between these two. Can you please talk a little bit about that?
Definitely. So the residential lease agreement is basic agreement between the landlord and the tenant, and doesn't have that much indications that this agreement is referring to something else but a residential unit, a studio, a villa, an apartment, or the usage of the unit is for residential. But the commercial agreement, from the moment that you open the agreement, start reading it, you will notice, you will realize that this agreement is for a commercial lease. First of all, some marks in the agreement is referring to the nature of the lease in this agreement. So basically, if we took in consideration the nature of the agreement, it will be for a commercial use. Permitted use only is commercial use according to the activity that they have been agreeing upon between the landlord and the tenant. The permitted use of the unit, if it's an office, then it should match what they have agreed upon, and actually it should match what is permitted by the building itself. Because here, some other regulations are trying to invade the agreement, and you're not only going to adhere by the agreement, you will also be obligated to follow what is regulated by the building management that you are in. I can remember that I have encountered the precedent where a spa took an office, not actually an office, it's a shop but it's into two sectors, an office and a shop. So both of them were for the use of spa. And one of the conditions is that the tenant must notify the landlord within a period of time that they have received the approval from the authorities to proceed and practice the spa activity, to provide the landlord with a trade license that shows that the activity is a spa, and then the landlord will allow them to proceed with their activity. While the tenancy agreement started at the beginning of the year until April, this is almost 4 months, the tenant couldn't actually provide the landlord with the requirements, and that's why the tenant found out that the landlord is raising an eviction notice against them and demanding an immediate eviction for the facility for failing to provide the requirements. So from this incident, we can say that there is some requirements that are additional to the tenancy contract itself. So it's not only about the tenancy contract that starts in and ends at. No, actually, it's the period of the time is very important, but still you will not be able to enter the facility, to enter the unit, to enter the shop, the retail, the warehouse, unless you're met the conditions that was agreed with the landlord. This is one of the key differences between the residential and the commercial lease agreement that I would advise before entering into a commercial lease agreement. You must know if this property will allow you to practice your activity without any conditions, or there are conditions to enter the property. So to make it easy, you can have the agreement, you will pay, and yet you can't start the activity because you are not meeting the conditions or the requirements that you agreed with the landlord. This is one thing. Second is the period. The period in the residential is in Dubai, in the Emirate of Dubai is 1 year, in the Emirate of Sharjah is 3 years. We can see differences in the Abu Dhabi also. It takes less than 3 years, but more than 1 year. There is like a period which is between 1 to 3 years in the residential units, but in the commercial leases, usually not less than 3 years, up to 10 years. So also the period, there are a lot of differences between the residential and the commercial lease in terms of the period. There is no maximum usually in the commercial. However,
I understand very well that there's not a commercial operation that would like to change their location every year or every other year. Most of them when they start, they would like to sign longer period. I think even less than 5 years makes no sense for a commercial operation to sign a lease, because because the address is quite important to their clients or to their operation. I understand that a lot of companies are even working on a remote basis, but maybe the smaller companies. But when it's an operation that have 5 to 10 employees who attend to the office every day, I can imagine that they would like to change the location every year or every other year, because the stability is part of the commercial operation.
100%. It's very crucial for them to have a stable place, to have a landmark. This is our place, we located here. And when they decide to shift, I think a lot of wasted fees are being paid to the marketing. Again, promote where we have located. Yeah. So we were there and we are located there because of a commercial lease agreement that we couldn't finalize for 3 more years or for another term of tenancy. So this is very important, actually, the period.
Part of it as well, I believe, is the investment that the companies do, because when you go into a residential property, you basically have several rooms, a kitchen, a balcony, and the big investment in a residential property is basically the furniture that you put in. But when you go into offices, every company have their own requirements when it comes to meeting room or how many cubicles or how many partitions. So you find a lot of companies investing in the office space. Yeah. This investment becomes a challenge later on if they want to move from one office to the other, because
Indeed.
that's a complete loss
Indeed.
if they keep moving. Have you seen a lot of conflicts in terms of the conflict between landlord and the tenant for the value of the fit out or the investment that the company did, or they don't want to leave because they have created something completely nice or completely different from what they received, and the landlord is basically asking them, in the terms and conditions of the contract, it says that you have to return the unit into the original state, which
100%.
is shell and core, for example.
Yeah, 100%. This is one of the most common conflicts between the landlord and the tenants in the commercial tenancy, is the fit out. So, of course, it's a condition that you need to return the unit in the same condition that you have received it, to make sure that the unit is in a clean and fit condition, and nothing is affecting the general view of the unit and how the unit looks like. So if you receive the unit that is painted in white color, you need to return it in white color, no matter is your decoration or your design. And I think that the commercial companies, or the ideology of the commercial companies, is that we will put in the fit out an X amount. We know that after 3-4 years, we will demolish all of this. But this X amount will give us the image that we are looking for, and that will bring us clients, and that will be a reason of higher income. So basically, from the landlord, from the tenant, if you allow me to use this decoration constantly within the entire period of the lease agreement, we are friends, and I have no problem with you. But the problem arises when the tenant already paid, like, let's say, $1 million dirhams for the fit out work, and it's the early quarter of the tenancy agreement, and then he finds out that an eviction notice for renovation from the landlord. I mean, he's talking like, seriously. I mean, you should have.
So this is kind of a risk if you sign a 1-year lease agreement for an office and you go through all the fit out
100%.
cost and so on, and you do not put it or regulate it in the agreement itself, what's going to happen in this
100%.
case. You can be paying the cost of all the renovation, leaving the office, but extra cost for demolishing and removing and cleaning the office, returning it to the conditions.
Exactly. So basically, one of the most important terms that needs to be added to the addendum is that, because this is actually is a compensation between both parties. It's a mutual agreement between both of them, and the law did not prevent agreeing otherwise on this part, because this part can find its roots in the civil transaction law, not the tenancy law. So the tenancy law provides the guarantee to the landlord that he will receive the unit again as he provided to the tenant, but it doesn't guarantee to the tenant that the landlord will compensate him in case the landlord decided to demolish the decorations due to a renovation, due to the landlord will sell the unit. A lot of disputes arise from here, and if there is one term that both of the parties agreed that upon the termination of this agreement, the early termination, which occurs from the landlord side, the landlord will compensate the tenant with X amount. This X amount is an agreed amount between the landlord and the tenant, doesn't require court verdict, and doesn't require any interfere from any jurisdiction. This is an agreed term between the parties that will guarantee two things. The first thing is that the tenant will have the full period of the contract. No matter the rental value of the same units in the same area or the same plot is being doubled or trebled, the landlord cannot force him to evict the unit for any reason whatsoever it is, because the landlord knows that he will or they will pay to the tenant what was paid in the fit out works. And the second thing is that the tenant will practice his activity during the 3, 5, 10 years, the term of the contract, while he's mind-free, he's stress-free. He will not be fearing this concept of, okay, I will not push that much money in the decoration because I'm afraid that tomorrow or after 2 months I'll find an eviction notice, and then I will have to go to the court to fight all the way 5-6 months to receive a compensation that will be decided by the court at the sole discretion of the judge, which might goes beyond the fit out works or way below the fit out works. And actually it's always going way below the fit out works, considering that the tenant have used the fit out works for quite some time, for 6-7 months. So if you paid 1 million, you need to pray to receive 300,000. So this is the issue. This is very important part, and it should be taken in consideration always.
Whenever we see a conflict between the landlord and a tenant, whether in commercial or residential, and mainly happen in residential, that the company start by trying to negotiate with the landlord, and then the landlord side just stick to the contract and say, whenever of course it's to their favor, stick to the contract, these are the terms and conditions, this is what we agreed on. This non-flexibility creates a conflict or creates a problem that might go to court. In some other occasions, we see that the tenant, especially on the commercial properties, when it's an office or a small enterprise in general, even a warehouse or a factory, that we see upon the failure of the project or a failure of the business, they tend to escape. They just leave the office as is, they close the door, there might be some furniture inside, and they leave. And the landlord now is not able to reach out to the tenant, and at the same time not able to use the unit and cannot enter the unit. This we have seen in court many times, but I would like to have your advice to both sides. What should they do if a situation like this happens?
In this situation, if I'm on the landlord side, leaving the unit without any notice will lead that you will not be able to pay me on time. So basically what you have paid, the checks will all be returned for insufficient funds, or for any other reason, close the bank account. You decided to close the bank account and you decided to liquidate the company and leave the country, and while leaving all the responsibilities, which is the lease agreement, one of them behind your back. As a landlord, I will simply request the court to evict the tenant for not paying me constantly 2 months. And then I will receive a verdict to evict the tenant. And then also I will request the court at the same case to execute whatever inside the unit of furniture or any movable items that could be sold and pay my due amounts. And then I will cancel the tenancy contract, and then I will proceed with another tenant. At this situation, there will be an execution file against the company, and you will pursue the company at this stage that the owner of the company will not be able to move many much around. Like, he will not have more choices but to pay you the penalties, the payment of the due amounts of the rental amount, and whatever is the court put in consideration against this company as a tenant. So from the landlord side, it's actually a benefit. It's actually something good that the landlord at the end of the day will be able to get the money and to get the unit.
Are you sure? Because maybe they get the verdict, but they cannot get the money.
Well, the movables, the furniture can pay off, but indeed the unit is way more important than the rental value.
Stop the bleeding.
Exactly. I need the first aid. I need something to, all right, the unit has been 2 months, there is no income, and I want in the 3rd month an income so that I can proceed my activity as owner of units and landlord. The landlord will not be that much damaged at the end of the day, but if I'm in the tenant side, I will never advise the tenant just to shut down everything and leave. At least the tenant is a commercial entity, and the tenant can take advantage of the commercial law, while the tenant can show an insolvency at this moment, and the tenant can stand before the court requesting the court to terminate this obligation, which is the tenancy contract, because it's an over obligation. The tenant cannot meet the requirements of this obligation, which is the payments. Basically, as a commercial tenant, he is subject to insolvency. He is subject to be in a huge obligation that affects the smooth income process as a commercial unit. So being a commercial or being a company in a commercial lease is actually an advantage to the tenant, not to the landlord. Because again, simply instead of closing everything and run away from the country, your company will become insolvent, and then you will have to leave the country. There might be an execution against you personally. You can sort this out either with the landlord directly by negotiating or through the court. The court will assist you and the court will help you because you're a commercial entity. You're not an individual in a residential contract. You're a commercial entity. You might have at some point a lot of obligations that exceeds your financial capacity, and at this time you will not be subject to penalties and it's your fault, and the UAE, the government, have stipulated many way out to the commercial entities that feels that the obligations became over than their capacity. They can't hold anymore. For example, I have a client who have a problem in the same situation and they can't make a good revenue. So instead of closing everything, leave the country, and they decided to put a full stop to this situation by negotiating the landlord. And unfortunately, the landlord was not actually helpful at all. And he doesn't want to show any mercy under commercial terms to the tenant. So the landlord refused, giving us no choice but go to the court and claim that we are not capable of
fulfilling the obligations.
Exactly, yes. Because it became a lot. And by this, I mean, by going to the court, I mean you need to go to the court prepared. You need to have the financial reports that shows that you are not making any money.
You apply for insolvency.
And I want to cancel the current tenancy contract based on these merits, all of these merits. At the end of the day, I can say that many judgments were in the favor of the tenants in the commercial entity. Many judgments have dissolved the tenancy contract between both of them. However, going back as a landlord, I still can sue the tenant before the court of the civil matters for the compensation for this tiny period of time, which is 2-3 months between the insolvency and the final judgment, as my unit was under the dispute in the court and under the tenant name by virtue of the tenancy agreement. You can seek 2 to 3 months compensation because before the RDC you will be brought as a respondent, but before the court of the civil matters you will bring the tenant as a respondent to respond to your claims that he have caused you damages due to the unpayment of the tenant, which will be relieved by the RDC.
Yeah, I see this balance between the regulations here protecting both sides. Like as long as the unit is being used or being occupied or not being used by the landlord to generate revenue from the rent, they will be compensated. But at the same time, it allows the tenant a way out in case there's a conflict or there is a financial situation where they cannot fulfill their obligation. So I can imagine that this balance is of course providing a little bit of fair situation whenever it comes to conflicts in this regard.
Absolutely.
Speaking of commercial contracts, we've seen a lot of contracts, especially with shopping malls. I mean, Dubai and the UAE in general is very famous of retail spaces with big shopping malls and famous shopping malls. The nature of these arrangements is that the shopping mall is putting a very rough, very difficult terms in the commercial agreements. In some occasions, you as a retailer, you have no choice of a location inside the mall. You just get a designated space. Of course, there will be an indication during the negotiation that you will be in a specific area in the mall, but legally and mentioned in the contract that you don't have much control where you will be situated inside, and the mall will have the power to move you from time to time or even to terminate the agreement while the retailer doesn't have the same right. Of course, it depends where are you in the food chain, if we can say it like that.
Exactly.
If you're a luxury brand that the mall is so much interested into bringing you into the space or not. But we see that the contracts are very difficult to prove. And I've seen cases where a big retailer in, I don't know, in fashion industry, and the management of the mall just decide to shut them down for a period of time for renovation, or because of there is a water leakage and so on and so forth. But in some other occasions, it's just for renovation of a certain area, and there's not much that the retailer can say. And there will be a big loss because the renovation of the retail unit inside the shopping mall takes a lot of cost. And of course, being well-known retailer, or even not so much in the luxury industry, or just, I don't know, a food truck that have benefited for a few years from the certain foot count on the shopping mall, and being existing next to another shop have brought them a lot of business, and being moved or being shut down for a while can have a significant financial impact on these companies. What's your opinion on the court conflicts that come from compensation of these fit outs, or even loss of revenues because of a landlord decision, which is the shopping mall in this example, to shut down an area or to move them around?
Absolutely. This is also very common conflict between big retailers and small to medium business. I would say the famous quote of pick your battles wisely. You cannot be small or medium size commercial entity that wishes to enjoy a huge mall facilities. Most probably you will be under very, very, very tough terms and conditions that will govern the contract, as you said. And at the end of the day, the resources of the retail or the mall are endless. And this is what actually happens there. One of the incidents that I have worked on was actually encountering the same situation, same scenario. After 8 months of a 3 years contract, the tenant found an eviction notice for the reason of renovation. Basically, what happened is that the mall decided to terminate the tenancy contract for the renovation reason, while at the end of the day, the mall couldn't provide an evidence that this unit needs a renovation. And the evidence are usually strict and pre-approved by the court, and everyone knows what are the evidence that this unit needs a renovation or not. But at the end of the day, the big malls and big retailers doesn't actually measure the things from this point of view. They measure the things from a different point of view, which is we have a lot of resources, we will pay you out, you will get out once we decide. So it depends on your weight, it depends on what exactly.
Well, how does the court see it? Because there will be a significant financial loss.
100%. And here comes again the rights of the commercial entity, which is a tenant. The court will preserve their rights, the renovation, although it was agreed or not in the commercial tenancy contract. It's very important to notice that you are contracting with a huge retail group, so you don't have that much of negotiation room, and you just decided to be there, to locate there for a reason. You need truly to pick up your battle wisely. When you decide to go there, you're building an 80% chance that you will be evicted before the end of the lease agreement. And also another companies and commercial entities are not being evicted, and they renew for a period and another, but we're talking about a possible scenario that you can face. In this case, you really need a financial capacity that can help you to reach a fair compensation from the competent court in such cases, because at the end of the day, it's the decision of the retail, it's the decision of the group. You will have to sign an addendum of 40 to 50 pages, which you will not be able to digest all of it, and you most probably will end up with either giving it to the professionals to say an opinion about it, or you'll just take the risk because you just want to be there, you want to exist there. And if you took the risk, then actually you need to take all the way. So either you will continue your lease period, you will pay your rental amount and you will gain benefits, or you will be evicted in 6 months, in 1 year, in 1.5 years, for a reason that God only knows. But you will not know the reason or the actual reason behind this notice. But at the end of the day, again, the court will preserve your right as a tenant with a minimum loss of 25 to 40% of what you have pushed as a capital to establish this facility for the period of the tenancy contract. So the fit out works, again, if it's not agreed within the addendum of the contract, then the expenses that you have paid to do all of the fit out works will not be fully compensated. It will be compensated according to the sole discretion of the court. So here is one of the loss points. Another loss point, you will change your location. Yes, 6 months ago, we opened here, we did marketing campaign, and we have pushed a lot of money to bring attention that we are located here. But then after 6 months, we're no longer here. Pick up your battles wisely.
Yeah, on this note also, I face this a lot when it comes to advising clients. Sometimes we've seen that they don't have enough documents that we can provide to court that talks about expenses. So they have done, as you said, marketing campaign towards this location. They have done spending on the activation of the location itself. Yes. By bringing entertainment or ushers or a marketing, an event company. Yes. They spend a lot of money on the renovation of the office with whether in materials or in professional work, but they don't have enough contracts and they don't have enough receipts to what they spent. Yeah. And everything that we cannot prove in front of court in writing for expenses is very, very difficult to claim back.
For sure.
So with this note, Ahmed, I thank you so much for coming and for being part of Monday Legal and for all the knowledge you share with us.
Thank you so much. It's a pleasure to me, and I'm honored to be hosted in Monday Legal.
Thank you so much.
Thank you.
This will be a dose from Monday Legal. See you next week.